You are listening to the Wealth Formula Podcast with Buck Joffrey. Get ready to change your life.
Welcome, everybody. This is Buck Joffrey with the Wealth Formula Podcast coming to you from Montecito, California. And before we begin today, a few things. First of all, there is a website associated with this podcast. It's called wealthformula.com, and you should visit there if you have not done so. In part because that's where you can get some of the resources associated with this podcast and sign up for some of our groups. For example, the Accredited Investor Club. We currently have, if you're in the group, you know there's kind of a smoking opportunity there right now. I can't really tell you about it because it is a Reg D 506B. In other words, it's only for accredited investors, but I mean, this is the kind of stuff that's not going to last, folks. I mean, it is 30% discounts. The fact that the Fed cut rates by 50 basis points last week is an indication of where we're headed. And so in that regard, we are clearly headed, and they've said as much. They're going to drop at least by another 50 basis points this year, to a descending rate environment. And a descending rate environment means that asset prices go up. That's just the way it works. And so if you're able to buy something right now, or let's say you've locked in something that cash flows given the interest rates currently, then you are going to do well. First of all, you're going to cash flow even more as rates descend, but also the exit value is going to be significantly more because cap rates go down with interest rates. And so when cap rates go down, that means that people have to pay more for properties. So that's basically how it works. I just think it's important. I know there is a tendency in these kinds of markets for people to sit on their hands, but I think it's something worth at least, watching. And if you are an accredited investor, make sure you're checking that out if you are in the group. If you're not, join the group and make sure you get an opportunity to see that. And of course, you have to be an accredited investor to do that, though. So let's talk about today's show. Speaking of things that you got to know about, asset protection. Okay, yeah, sounds really exciting, right? Well, it's actually, you can make this stuff kind of fun. And I have to tell you, you're going to have to, because one of the rude awakenings that I've had over during my adult life in my career has been the nature of the legal system in our country. The thing is, it's not like the movies, right? It's not really about who's right or who's wrong, people going to trials and justice prevailing. It's about risk mitigation. In my former life as a practicing surgeon, I saw this in the form of a handful of little malpractice suits. That may sound like something really bad, but experienced surgeons will tell you that if you have not had some complications during surgery in your career, well, you simply have not operated enough, because they happen. They do. It's human, and it's human from both ends. Things don't go always the way you plan them for. And that's why, as surgeons, we have robust consent forms and processes, making sure that patients are aware that complications are always possible, and in fact, they do occur. I had another professor once say that the only procedures that are minor procedures are ones that other people are doing, because he didn't consider anything that he was doing minor, because he was afraid that he would get burned. And anyway, the point is, so like I said, I once had a complication in a procedure that was well known. The complication that is. It's a well-known complication. In fact, the consent form specifically named this complication multiple times in the consent form, even provided the incident of this specific complication based on published studies, right? Unfortunately, the patient decided to file a malpractice suit against me, even though he recovered just fine. So I guess from his perspective, why not, right? If lawyers are telling you, hey, do this, there's a chance to make a buck. On buck in this case, by the way. Why wouldn't you do it, right? I mean, it's the American way these days, this whole legal suing people, suing everybody. So anyway, I was appalled when I found out I was getting sued, and I thought for sure it would go away. I mean, after all, this is ludicrous. This was like something we talked about. It was in the consent, and it happened, and he's okay. So what's the problem? But as it turns out, my attorneys felt that it would be just smart to have insurance settle the case rather than risk a bigger loss by going in front of a jury. So I did it. Since then, I will tell you, I'm jaded now because I've been in multiple business litigation matters. And again, it's not about who's right or who's wrong or justice. It's about calculating how much it would cost to continue with lawyers rather than an evaluation of the merits of the case. That's just the reality. Bottom line is, it's not about who's right or wrong. It's about who's got the money and who's willing to spend it. That's why, now you're going to think this is funny, but the best defense against frivolous lawsuits is to turn yourself into a really, really ugly target. That's the truth. You want lawyers to look at you and realize that trying to get money from you is just not worth their time. And that, my friends, is the basis of asset protection in the United States of America. Sounds cynical, I know, but that is the truth. So how do you turn yourself into a skunk that no one wants to get near? And that's what this week's show is all about. My friend and asset protection attorney, Doug Lodmell, who is extremely well regarded as an asset protection attorney. He's the inventor of something called a bridge trust, which is used all throughout the country. Doug is going to tell us everything we need to know about asset protection over the next 30 minutes. Don't miss it. We're going to be right back and have that interview. Welcome back to the show, everyone. Today, my guest on Wealth Formula Podcast is no stranger to the show. It's Doug Lodmell, my friend and also my attorney who specializes in asset protection. Doug, welcome back.
Yeah, great to be here, Buck.
So we are going to do a refresher here, and this is a topic can sound intimidating to people, right? It is asset protection, and it sounds like this nebulous thing. I remember coming out of residency training and being like, what the heck is asset protection? I don't even have any assets. What am I protecting, and why do I need this? So what we're going to try to do here in 30 minutes, and I'm confident we can do this because you're good at this stuff, is we're going to give everybody a 101, the basic stuff you have to know about asset protection. So let's start with that. What's the most important thing I need to know about asset protection?
Well, the most important thing is that it exists, right? A lot of people don't even know it exists. They think, oh, well, I can't do anything about it. I can buy insurance and that's the limit. So you actually can do something to specifically protect your assets. You're not just fully dependent on insurance as the only line of defense for risks that involve the legal system. And that's what we're talking about here. We're talking about legal system risks. We're a country that has more lawsuits than any other nation in the world. Probably all the nations put together don't equal the amount of lawsuits in this country. It's just a national pastime. And so if you have assets, if you're in a profession where you're at risk, whether you're a professional, a doctor, a lawyer, a CPA, whether you're a real estate investor, a developer, whether you have employees, all those things generate risk. And as you build assets, you start to wake up and go, geez, I'd like to not lose everything I've worked my whole life for. And so number one, it exists. You can actually do something to protect your assets.
Okay, so let's start with the first layer. Let's say I'm going to put the scenario out because I want to approach this as, that dumb kid coming out of residency that I was many years ago.
Yeah.
Okay, so I'm coming out of residency here, Doug, and I'm starting a practice. Why do I need an LLC, or do I need an LLC, or what is this whole thing all about?
So yeah, that's a great place to start, because the idea is that there's a concept called separation of ownership and beneficial use and enjoyment, right? So you can have the ownership over here in a safe place, but you can still beneficially use and enjoy the assets. So the way we do that is what you mentioned, an LLC or a corporation or a limited partnership or some legal tool, even a trust, where the ownership is here and it can be put in a safe place. And then we still get to use and control the assets. That's one of the key tenets or the key concepts of asset protection, is this separation of ownership from beneficial use and control. So if you're coming out of residency, you're starting a practice, you probably need an LLC for your practice itself or a corporation, just to start creating that separate identity of what is the corporation do versus what I do. Now, when you're a professional, there's lines that are easily crossed because you're the one prescribing, you're the one with the knife and doing the surgery. So you can't fully get out of the liability. That's where insurance comes in. That's why you have professional, malpractice and professional insurance, so that when those things happen inside that business, you're still covered. But that's your first concept and your first step. And so you probably need that before you have any assets, just when you start a business.
Yeah. So again, we're gonna keep coming to this idea of this duality, or not only just duality, but the separation of the personal self from assets, and that's really going to be the recurrent theme. So in that scenario, the LLC would own, say, the practice, and you are separate from that LLC, and so in theory, that separation is saying, hey, what happens if I get sued? That doesn't affect the stuff in the LLC. If the LLC gets sued, that doesn't affect me personally. Now, I know it's more complicated than that, but at theoretical, at a high level, that's conceptually kind of what you're trying to do, right?
Correct. Yeah, conceptually it is. No, again, when you're talking about your professional practice, the lines are a lot more blurry. But let's move to now you've been practicing a few years and you're actually going to buy your office building. So that's your first big purchase. You're going to buy this office building. Now we're going to want that in its own LLC. So we create an LLC for the office building. And then the practice LLC would lease the space from the holding company LLC that holds the real estate. Now the separation is even more clear, because that is just holding an asset. And so if something happens in the practice, the real estate could be safe from that liability of the practice. Or if you get in a car accident, it can be safe from your liability. Or if something happens in the building, then you can be safe from the fire or the slip and fall or whatever happens inside the building. So we're protecting both directions by using this separation concept.
Yeah, so effectively now you've got three separate things here, and each of them has their own liability. And in theory, each one of them is protected from each other's, from lawsuits, creditors from each other. And again, I know that's where the
little oversimplification, but in concept, to get the concept laid down. Yes. That's the right concept.
Really, you need an asset protection attorney for the fine details, but this is where we're starting to layer things on. Okay. So now I've got a building and now I'm making money, and now I want to invest that money. Okay. How do I take that money and take my investments and separate myself from my investments? Because that might be a good idea as well.
Right. So we already have a building LLC, but do we want to add investments into that? No, because it has its own risk. It has its slip and fall risk, and can burn down. So we don't want to mix your assets, your investment money. So we're going to create another company. And in this case, we're actually going to go up a layer. So we're going to go to a company above your real estate holding company and call it your primary holding company, or your overall holding company. And that's where we could do your safe investments. So in asset protection, we make a big distinction between risky assets and safe assets. Risky assets are things that are physical in the world. They have a key, a door, a lock, an engine, a propeller. Those things are risky because they can hurt somebody. Risky assets, we really segregate into their own little buckets, which are almost always LLCs.
By the way, real estate is a risky asset. So that's a...
Oh, yeah.
Right. So that's not going to go in your holdco, your hold company.
No, it's going to go in its own LLC.
Right.
Which in turn, once the LLC is wrapped up, then it can go in your primary holdco. It can go up into the primary holdco, but only after it's first wrapped up in its own LLC.
Right.
Safe assets like investments, syndication deals, stocks, whatever, those can go directly into your holdco because they're safe. They're not going to create risk.
So basically, and again, just to simplify and try to make this clear, the holding company in this situation is almost like a piggy bank, right? You got this piggy bank, and that piggy bank, when it goes and it invests in things that do not have liability. So for example, if you are a limited partner in real estate, you do not have liability. So that is a safe thing to put in your holding company. You can have a brokerage account owned by that holding company, and that would be a safe thing to do at the holding company level. And then the holding company itself could own potentially other LLCs that they might have risky assets in them. Is that correct?
You got it.
Okay.
Exactly right. Yeah. So you're separating and yet you're still consolidating, because from a tax perspective, this is going to be much easier on your CPA.
Yeah, that's right. And that's, by the way, that's a completely different topic, which is critically important. But one of the reasons we do this involves all of the tax implications of this as well. So in some regards, asset protection and tax are, they're massively intertwined. And you have a tax background too, right?
Yeah, I do. I have a tax, they call that a legal letter master's. It's an advanced law degree in taxation. So, and it's been very helpful because asset protection involves creating companies, and then ultimately you have lots of tax implications. And so we've definitely, when you design an asset protection structure, you really want to be thinking about the taxes. If you get it right, it's almost certainly going to be beneficial.
Yeah.
You're going to be able to start shifting income and creating more passive income, and especially if you're trying to utilize passive losses. But again, beyond the scope here, maybe we should do another one just about that. But yeah.
Okay, so now I've become a very successful doctor, and I am piling on those LLCs with big assets in them. With my holding company's got a couple million, multiple $1 million of stocks, bonds, limited partnership holdings. Now, the next thing you know, there's another layer that you might want to add, and maybe you could talk about that and when you might consider this layer.
Yeah. So once you get to a certain point, and it's kind of that $1 million, $2 million mark of assets that are inside of that holdco that are protected, but at some point you get enough in assets where a domestic holding company structure may not feel secure enough and may not be secure enough, because there are, even though the domestic structures like LLCs and limited partnerships are very powerful, they have their limitations. You can only protect so much. And this protection is really based around this concept of a charging order. So if it's somebody, to simplify it, if somebody gets a judgment against you and you have $3 million sitting in your holdco, they can't reach that $3 million, but they can get a charge against your interest in it. And if and when you ever make a distribution, they're in line for that distribution.
Okay, so
it's not full protection; it's deterrent protection.
Yeah. So, and it also creates, but that even though there's that charging order, it also, as you called it, a deterrent. So a lot of asset protection, in fact, is done not because necessarily it is bulletproof, but because it creates a massive pain in the ass for somebody who's suing you and trying to get at your assets. Would you talk about that?
Yeah, I mean, that's really the primary purpose of asset protection, is to create such a difficult pathway to your assets, even if somebody is successful in getting a judgment, that they want to settle with you because maybe they can get them in 5 years or 10 years or 15 years after tons of legal fees and so forth. Maybe they won't ever get them. And so the deterrent effect is very real. And this plays out very much before they actually have a judgment. So understanding how the legal system works. So let's say you get into a car accident, it's your fault. Let's say it's even worse than that. You were drinking, so it's really clearly your fault, and somebody has a really bad injury and it's going to exceed the insurance. Absolutely, no doubt about it. In that case, the person suing is looking and going, well, we have a really good case. We're almost certain to win a multi-million-dollar judgment. Let's not settle for the insurance. Let's go after this guy because he's a successful doctor. Well, if they find out and that's again part of the strategy, they find out that, yeah, he has assets, but they're going to be very difficult for you to reach, then it starts to be a different calculation as to whether
very difficult and very expensive, very difficult and very expensive. So legal costs in general, this is the lesson that I have unfortunately learned in middle age as a business guy, is that it doesn't matter sometimes if you're right or wrong. It's like, are you willing to spend the money, or, do you have the money? Whoever has the money sometimes wins. That's the sad part of the legal situation, right? So
very much so. It's like poker table. The guy with the big stack of chips in front of him has really got all the power at the table. So, you don't know if you're going to be that guy, and most likely you're not, because there's a big claim. So all that was being said to kind of frame that the domestic structures, the LLCs and the holding companies, they're good, but they're not the best thing that you can add. There's one more layer, and that layer is called an asset protection trust. And we use it on top of the existing structures. So we're not replacing those structures. So we layer it up and we build them and we continue to use them. So we're going to keep those LLCs for all the real estate and the risky assets. We're going to keep the holding company or companies for all the safe assets and all the interest in the risky asset holding companies. And then on top of that, we add what's called an asset protection trust. And these trusts are very unique in that they are specifically designed to protect assets. That's literally their whole purpose in life. That's all they're meant to do. They use laws of certain jurisdictions that accomplish that. Those jurisdictions have literally drafted statutes specifically for people to utilize to protect assets. And so that's really the 900-pound gorilla in the asset protection world, is the asset protection trust. And again, once you kind of get to $2 or $3 million of assets, you really want to be thinking about an asset protection trust, and possibly less. I have a lot of clients that have $1 million or even less that still utilize it because they can't afford to lose what they've got, and they really want to take and do the maximum.
Let's talk a little bit about how this works, because I've sort of encountered a little bit of the complexities around assets that you own that are liquid and those that are, for example, real estate.
Right.
There is a little complicated in those situations, right? Talk about sort of that issue that comes about when you have a trust owning an LLC. That owns real estate. How do you protect that, right? I mean, in that situation, basically, you would theoretically be selling real estate and then making it so that it could be moved into a trust or something like that. Is that the idea?
Well, so let me back up a little bit and just kind of bring in this other concept of the jurisdiction.
Yeah.
So in the world of asset protection trusts, which we mentioned, there's really three different ways you can do it. You can do them either fully offshore, fully foreign. And this was this is the first jurisdiction that passed the statutes. 1984, the Cook Islands passed a statute. You can do it fully domestic in one of the 20 or so jurisdictions in the United States that have passed specific domestic asset protection trust legislation, or you can do a hybrid of the two, which is called a bridge trust. So when we talk about the foreign trusts, the advantage of those is they are not subject to the U.S. courts at all. They're just not subject to it. So you can take your judgment down to the Cook Islands. It's worth nothing. And you have to start over. You have to prove your case beyond a reasonable doubt. It's incredibly difficult. So this gets into the concept, okay, you're in a big fight and you want to protect your assets. You've already got your asset protection structure set up, and it's been set up before you had the problem. This is a key concept. You need to set this up before you have a need for it. So if you're listening and you've got the assets, now is the time to be thinking about it, not, oh, I know about it, I'll wait till I have a problem. Because once you have a problem, you have a problem. It's like buying insurance. Once they've named the hurricane, you're not going to get it done. So once you've set it up, now you have a problem. The very, very highest level of protection is the foreign trust, and to have the assets physically moved away from the U.S. courts. So opening up a Swiss bank account, moving your cash, your stocks, and your investments, and so forth, all the way to Switzerland. That is the very, very highest level. And then everything else works down from there. Now, does that need to happen to protect the assets? No, it doesn't. Just having the trust, owning the holding company, which owns the assets, is already a massive deterrent. And any lawyer looking at this is going to be thinking, oh, geez, not my favorite type of case, right? Even if I get this judgment, I have a huge collection issue. However, it's obviously easier to protect liquid assets that can be moved to Switzerland than it is physical assets. And this gets to your question, what do you do with real estate? Let's say most of my assets are in this big real estate portfolio. I've got $10 million of real estate sitting in, 15 different states in 40 different LLCs. Okay, great. You are going to then look at the case. I would say 95% of the time, Buck, you're not going to need to sell the real estate and go, pull the nuclear option and throw everything out of town, because just that structure itself is going to be incredibly deterring to anybody looking at it. But let's just go to that ultimate case, right? Let's just say, okay, well, you know what? This is not the 95% of the time. This is the 5% of the time. The case is so bad, they're not going to stop until they have gotten every asset, and they don't care how long it takes, and they don't care how much they spend to get it. In that case, yes, the only way you could really be sure is to start selling the assets.
And that wouldn't
sell the real estate.
And that wouldn't be considered fraudulent transfer?
No, because the assets, as long as the assets are already in the trust. So that's what we have to make sure that the trust is set up. So if the LLCs are owned by the holding company, and then the holding company is owned by the trust, then the real estate held by the LLCs is already in the trust. So if you sell the real estate and then move money directly to the trust, there's no conveyance in terms of fraudulent conveyance, because the trust already owns those things. Which is why this is so critical to set up before you have a problem. If you try to set it up and do that after the lawsuit, then that doesn't apply.
Can this actually protect criminal activity? In other words, I'm asking this because I'm witnessing something that might be some criminal activity in a lawsuit, and I wonder if there's protections there for somebody who's done something wrong, who's got issues and regulators coming after him. So if the IRS wants money, or if the DOJ or the FBI or whatever, and they're set up with this kind of trust, is there a way for them to avoid the creditor, even if it's that kind of creditor?
So the short answer is the asset protection itself can still work regardless of the creditor, but that's probably a smaller consideration for somebody who's facing a criminal penalty, because their jail is probably the bigger consideration.
Yeah, right.
So of course, in almost 30 years of doing this, I've seen plenty of cases, and definitely have seen some criminal components in some of these cases. And I would say the most common way this goes down is that the action happens, the client is indicted or investigated or whatever. The thing happens, and I get the phone call, and they want to know what the next steps are. My first question is there a criminal component? If the answer is yes, let's talk to your criminal attorney.
Yeah.
I would say every time I've had that conversation with the criminal attorney, their answer was, well, if he wants to protect his assets, I can almost assure him he's going to jail.
Yeah.
So you probably want to think about which one's more important.
Right. So there was a case I remember, and tell me if I'm wrong. There's a guy named, I think his name was like Kevin Trudeau or something, and he was like on TV all the time, and he got in trouble with a regulator. It was a television regulator, whoever does that kind of thing, and had a huge
FTC.
Yeah, probably. FTC. He had a huge fine he had to pay, and apparently he didn't have to pay it because he had one of these trusts set up. And so I guess that's kind of my thought too, is like, can he, because his was not a criminal thing, it was a civil thing, I think. And so, but regulators were still after him, obviously, with the FTC, but he was able to not pay it because his assets were offshore.
Well, yeah. So if you just back up and kind of look at how asset protection works, if in the context of a foreign trust, the asset protection works because the trust itself is domiciled in this offshore jurisdiction, like the Cook Islands. The assets themselves are domiciled offshore in a jurisdiction like Switzerland. So nothing is here. So nothing can be reached by any kind of U.S. system, whether it's a court or a governmental agency or whatever. So again, the answer is that asset protection offshore, foreign asset protection, when the assets are also offshore, is incredibly effective. I mean, there are cases where we have a case where client dies owing the IRS $38 million. Assets are all in the trust sitting offshore. IRS couldn't reach the assets. The wife still had access. So yes, it works, but that is not. It's not the way I like clients to think about this.
Yeah.
Because it's not that simple. There are always other considerations, and so whether you even want to try to make that work in that situation, and in virtually every case I've been associated with, that was not the priority. The priority was staying out of jail if it was criminal.
Yeah, yeah.
And I will tell you that when there is governmental action, they are very good. They have figured out the formula. The formula is get some kind of criminal component here. And even if it's as simple as a wire fraud charge, right?
Yeah.
So you could have a wire fraud charge. Now it's criminal, and now we're talking about 10 years in jail. And even if it's a weak charge, doesn't matter. The considerations change completely. So yes, it's that powerful, but no, it's not really a good idea to think of it in terms of being able to avoid, governmental agencies and creditors. And again, depending on who your asset protection attorney is, there's how you draft your trust can also have an impact on that.
You are the inventor of something called the bridge trust, which is a lot of attorneys are using, and I want you to tell us about that, because there's a lot of advantages to having an offshore trust, but there's some disadvantages too. And what you've been able to do is to have your cake and eat it too a little bit. So will you talk a little bit about the design of that and who might be appropriate?
Yeah. So my question to myself, 27 years ago was, gosh, this offshore asset protection is fantastic, but it really does come with some costs. First of all, you have an offshore trustee in control of your trust. That's an expense that you have to deal with. And then you also have compliance. I mean, when you have an offshore entity, the compliance is different for a trust. You have different forms you have to fill out. The penalties on those forms are pretty significant if you miss one. So for most average people that are the kind of people we're talking about, the doctor who's become really successful, or the investor, or the business owner, having a fully foreign trust is really kind of overkill. When the domestic trust came online in 1997, 98, late 90s, that was for a lot of people the answer. They're like, oh, great, we don't have all this offshore. But then the cases started coming out and they didn't hold up very well at all. And so, that's not a real solution. But there were some advantages to staying domestic. You didn't have that foreign compliance, and you don't have to get comfortable with, some offshore jurisdiction. So what I asked is, well, can I have both? Can I actually get a little bit of both? And the answer was yes. And so I actually designed a trust, which is designed and starts life as an offshore trust, as a foreign trust. So we actually drafted as a foreign trust, we register it offshore. But then for the purposes of compliance with the IRS, which happens under Code Section 7701, we actually bridge it back and we treat that trust as a domestic trust for tax purposes. So the advantage is that we make the foreign trustee a successor trustee, not a present trustee. And we make a U.S. person the present trustee, which is part of meeting that test, and a U.S. jurisdiction, the jurisdiction for the trust, which is the second part of meeting the test under 7701. And so what we end up with is a foreign trust from the eyes of the foreign jurisdiction, because it's registered there, and in their eyes, it's foreign trust, but a domestic trust in the eyes of the IRS. And this makes it very simple to manage. It doesn't have that foreign trust compliance requirement. You don't have to fill out those forms. You don't have to even do a tax return for the trust separately, because it's a grantor trust, which means disregarded for tax purposes. So we get all the benefits and a massively reduced and simplified maintenance regime and structure and cost structure. It's just much less expensive to maintain a bridge trust than it is a foreign trust.
I was just going to say, if you end up with a big problem, you flip a switch, right?
Yeah. So if you end up with a big problem, you call the protector and you say, hey, I've got this big problem. The protector has the power to declare an event of duress, which is the big problem. And then at that point, that foreign successor trustee comes in as an active trustee. And then they start taking actions to protect the assets of the trust, including removing the U.S. trustee, which is often the client themselves, moving the assets physically offshore, opening Swiss bank accounts, doing whatever it takes. And so and at that point, now it's a foreign trust, because we're under 7701, it's now considered foreign. And then you have to do the compliance and you have to do all the things. But at that point, that's not really a big issue. You're using the trust. And so it's worth paying that extra expense and having those extra compliance documents, because you're using the trust. And so you get the benefit of the foreign trust when you need it, but you get the simplicity of a domestic trust until you need it. And, for the vast majority of my clients, they're not going to have to cross that bridge.
Right.
And again, the
no pun
deterrent effect
intended.
is still there.
No pun intended, right? You don't have to cross the bridge.
You don't have to cross the bridge.
I like that.
Exactly.
That should be your slogan for the bridge trust. Let's just hope get a bridge trust, one that we don't have to cross.
Yeah, probably won't need to cross. But if you do, it works. That's the thing. If you do, you've already set the trust up. You've already met all the timing guidelines. You've funded the trust. You're not waiting to fund it. It's funded with the majority interest in that hold company, and then all the LLCs and everything else, and even direct assets in some cases. So it's proven to be incredibly effective and very popular because of the lower maintenance cost and the lower setup and the simplicity and the compliance.
So what I will say is I have one of these, and many of our listeners have this. And I know we have a lot of new listeners since Doug's been on before, and I highly recommend that you talk to him. You may not decide that this is for you, or it may not be time for you right now, but Doug, as a friend of the show, will do a free consultation with you, right? Doug, you want to talk a little bit about that?
Yeah, I mean, you're welcome to contact us, and we'll take 30 minutes or 40 minutes, whatever it takes, and we'll just go through your assets. We'll look at your risk profile. I'll help you understand what's already protected, because there are things that are already protected, like your homestead in certain states and 401ks and IRAs and so forth. So we'll give you a good idea at the very least of just, okay, I've got, $2 million of assets, and 1.2 of it is already protected. For the unprotected assets, we'll give you a plan. We'll say, okay, well, here's how we would recommend setting it up to protect it. And so it's very valuable to just have that information. A lot of people just after that call already, they've gotten incredible value just knowing what's already protected. So we really encourage, even if you don't think you're quite there yet, we're happy to do the call.
And Doug, how do we get a hold of you?
So you can just contact us directly. support@lodmail.com is our email. You can call our 800 number, 800-231-7112, or go online to lodmail.com and just go to the website and fill it out. But if you're a listener to this show, please come in, and I can give you a link for you, Buck, so that your listeners can click that link and fill out a form, and that way we'll know exactly where they come from, and we'll treat them like kings. Yeah,
fantastic. Well, again, I want to point out again that this is a great opportunity. Doug is extremely well regarded in this space. I mean, he invented the bridge trust, which if you go to your local asset protection guy and say bridge trust, he'll know what a bridge trust is, and Doug invented it. Yeah. And you're getting an opportunity to talk to him for free about your situation. And I just think if you don't have anything in place, or even if you do and you want Doug to take a look at it, why wouldn't you do that? So, Doug, want to thank you so much for being on the show again. And yeah, there's so much more to talk about, but I wanted to, do the 101 real quick, and I think we did it.
Yeah, that was great. That was fantastic. Thanks for having me.
We'll be right back. Welcome back to the show. Hope you enjoyed it. And make sure you give Doug a call. I can't tell you how many people kind of just ignore this. The problem with ignoring this is it's sort of like ignoring insurance, right? Of course, insurance itself is part of asset protection as well, but it's the same type of reason that people don't get insured, because they don't think they're going to need it until it's too late, because this stuff doesn't work very well if you haven't actually put it in place before you need it. I highly recommend Doug and his firm. Tell him that we sent you, just because he is a very good friend of mine, and he takes really good care of our folks. And what do you got to lose? Free consultation with a guy who's a very high-powered, expensive attorney, just because you are a listener of Wealth Formula Podcast. Anyway, that's it for me this week on Wealth Formula Podcast. This is Buck Joffrey signing off.
Thank you for listening to the Wealth Formula Podcast. Visit us on the web at wealthformula.com. The information contained in this podcast are opinions, not fact. As always, consult your own financial team before making any investment. See you next time.